Have you ever heard a builder saying, "We cannot give conveyance right now because future FSI, future TDR, or redevelopment potential is still available on the land"? Well, the Bombay High Court has delivered an important judgment that may impact thousands of cooperative housing societies across Maharashtra. The court has clearly stated that conveyance cannot be delayed merely because the builder wants to preserve future TDR or future development rights. What exactly happened? Why did the builder oppose the conveyance? What did the court say about TDR and reserved land? And what does this mean for housing societies seeking deemed conveyance? Let's understand this landmark decision in simple language. This dispute relates to three cooperative housing societies located in Ville Parle, Mumbai. The societies consisted of 10 buildings constructed in the 1970s and two buildings constructed around 1990. The land involved was a large plot measuring more than 5 acres. For years, the societies were seeking conveyance of the land and buildings in their favor. As many of you know, conveyance is extremely important because it legally transfers ownership rights from the builder to the cooperative housing society. When a builder refuses to execute conveyance, societies often approach the competent authority under the Maharashtra Ownership Flats Act, commonly known as MOFA, and seek deemed conveyance. In this case, the deputy registrar granted unilateral deemed conveyance in favor of the housing societies. However, the builder challenged that decision before the Bombay High Court. Builder's argument. The builder's primary concern was future development potential. According to the builder, a portion of the land was reserved for public amenities, such as municipal market, primary school, road widening. The builder argued that in future, if these reserved portions were acquired by the municipal corporation, the builder could become entitled to valuable TDR benefits. TDR means Transferable Development Rights. In Mumbai and other cities, when land is surrendered for public purposes, the owner may receive development rights that can be used elsewhere or sold. Therefore, the builder wanted to retain control over the land and argued that conveyance should not be granted because future TDR benefits could arise. In simple words, the builder's stand was, don't transfer the land now because valuable development rights may be generated in future. What did the High Court say? 430-730. Justice Sandeep Marne was not convinced. The court observed that conveyance of the land meant for the housing societies cannot be indefinitely delayed merely because of hypothetical future benefits. The court made a very important observation. It stated that until the municipal corporation actually acquires the reserved land and compensates the concerned party through compensation or TDR, the possibility of future development rights cannot be used as a reason to stop conveyance. The court described the builder's argument as a novel idea that was preposterous to the core. In essence, the court said, a builder cannot hold societies hostage by claiming that some future TDR may arise one day. Housing societies are entitled to obtain conveyance of the land and buildings that belong to them. Potential future development rights cannot become an excuse to postpone their legal entitlement. This observation strengthens the purpose of deemed conveyance provisions under MOFA. Partial relief to builder. Interestingly, the court did grant partial relief. Earlier, the deputy registrar had granted deemed conveyance of the entire 5-acre property. The High Court modified that order. Instead of conveying the entire 5 acres, the court directed conveyance of approximately 4 acres. The remaining portion related to reserved land and other disputed areas. Therefore, while the builder did not succeed in stopping conveyance, the court balanced interests by excluding certain portions from the conveyance order. Important observations for housing societies. 8:45, 11 o'clock. This judgment sends a strong message. If a housing society is otherwise entitled to conveyance, checkmark, future redevelopment possibilities cannot stop conveyance. Checkmark, Future FSI potential cannot stop conveyance. Check mark. Possible future TDR benefits cannot stop conveyance. Check mark. Builders cannot indefinitely retain ownership merely because development rights may arise later. The objective of MOFA is to ensure that societies receive legal ownership of the land and building. Allowing builders to postpone conveyance for speculative future benefits would defeat that objective. Practical example. Imagine a housing society completed 30 years ago. The builder refuses conveyance and says, asterisk, one day the municipal authority may acquire a portion of this land and I may get TDR worth crores of rupees. If such an argument is accepted, societies may never receive conveyance. The High Court has effectively clarified that speculative future benefits cannot override the society's present legal rights. Legal takeaway. The key takeaway from this judgment is rights of flat purchasers and housing societies take precedence over uncertain future development benefits claimed by developers. Deemed conveyance cannot be stalled merely because the builder hopes to receive TDR or exploit future FSI potential. Conclusion. This Bombay High Court ruling is likely to be welcomed by thousands of cooperative housing societies across Maharashtra that are still struggling to obtain conveyance from developers. The judgment reinforces the principle that conveyance is a legal right. Future TDR expectations are not a valid ground to deny or delay that right. What do you think about this judgment? Should builders retain future TDR rights, or should housing societies receive complete ownership without delay? Share your views in the comments. If you found this explanation useful, like the video, subscribe to Asterisk Corporate and Securities Law Compass Asterisk and press the bell icon for more updates on property laws, cooperative societies, corporate laws, and landmark court judgments. Thank you for watching. Disclaimer. Viewing this video or accessing the content on this channel are free and does not create any professional, advisory, or client relationship between the speaker and the viewer. The content is shared solely for general educational and informational purposes. The speaker is a member of the Institute of Company Secretaries of India, ICSI. However, the information provided in this video should not be construed as professional advice, consultancy, or opinion under any law or regulation. Viewers should not rely solely on the information provided in this video for making legal, financial, regulatory, or compliance decisions. Any person intending to rely upon or act on the information contained herein should independently verify the relevant provisions of law and, where appropriate, seek professional advice from a qualified professional. The speaker, the Institute of Company Secretaries of India, ICSI, and any organization or listed company with which the speaker may be associated shall not be liable for any direct or indirect loss, damage, or consequences arising from reliance on the information provided in this video or channel. The content shared on this channel is based solely on publicly available information, general legal provisions, and academic discussion of corporate and regulatory frameworks. The speaker confirms that no unpublished price-sensitive information, UPSI, confidential information, or proprietary information of any listed company or organization has been disclosed or discussed in any video or content on this channel. The views expressed in the videos are personal academic interpretations for educational purposes only and are not connected with or derived from any confidential information obtained through employment, professional engagement, or association with any listed company or organization. Nothing contained in this channel should be interpreted as market advice, investment advice, or insider information under the applicable provisions of securities laws, including the SEBI Prohibition of Insider Trading Regulations 2015. Viewers are advised that the information shared is purely for general educational awareness and should not be relied upon for investment decisions, trading decisions, or regulatory compliance without consulting appropriate professionals and official sources.